Welcome to Obidati Family TV. The program now Hope Alive. Yes, hope day. And not be small hope, now plenty hope day. Today we get breaking news from our way from America. And the one where we say they happen for Nigeria. Peter Obi and Atiku, they don't they lead the way where they carry us to they go to Supreme Court. The place where we want hear the thing where they want talk about waiting Samani and the gang do commit against over 200 million Nigerians. We go bring again the one where we say far away for United States of America. The Judge Gilbert don't talk say not be only make them release that document where records of academic this thing for Tinubu where they tie since with the struggle since it not be only that one. Then talk say they must swear under oath say that very document where then they give say they authentic. Then they call on depositions. That one, if they come this hour. We go even bring the video where we say been audio where the judge talking, where we don't talk before, say this very thing wuru dey inside. He gets hand, whether na monkey hand don't chook enter another place. All this one we go carry and enter, but plenty talk go for the relief where we say people will be they sick. Because some people no seriously understand the thing where they for this rogue judgment will come out from Samani. So we go bring them out, waiting. We go carry, they go the Supreme Court. Waiting we want make them answer and make them reverse, or from there, make them give us our mandate back straight. That one, now our own analyst, Max Twan, and go give us all that orders. It's in the waka, they go for Supreme Court. Back here for studio, I get Angel for here. I get Esther and Princess Tandagidibam.
Welcome, my well-meaning Nigerians. Good day, my well-meaning Nigerians. My lovely and intelligent, obedient worldwide. Welcome, tell your neighbor, say hope day. New Breed newspaper 1919 don't talk am already say drug baron may determine the Nigerian politics. My people, it don't they happen today. Welcome on board. Let's discuss.
Yes, so wonderful, obedient and 1 million Nigeria. So now welcome on board. Welcome to Hope Alive. My people, even as we head to the Supreme Court, time has come when we should hold the judiciary accountable to statutory laws, because they don't have the right to make laws. They only have the right to interpret laws. Justice should not only be done, but it should be seen as done. Welcome and join the conversation.
Good day, well-meaning Nigerians and fellow obedient worldwide. We'll also be talking about the Samani's ruling that gaslighted the issues by dismissing LP's witnesses as incompetent and not specifying polling units. All this and more we'll discuss. Welcome back to Hope Alive. Yes,
if you see all our people, they sharp for studio here. The one will be say AJ carry come 1990 na prophecy. Now we see for that very one, NJ they carry prophecy. As the thing take me, say drug barons. News. Okay, this one na news breed newspaper. Where then they sell 10 naira for that time, November 15th, 1990. 10 naira and then they sell them. And waiting them put there, I don't know the person where face they there anyway. So, but they say drug barons may determine Nigeria's political future. Anyway, it be like saying how many years from 1990 for now? No be 33 years, I be 33 years. So 33 years, now they won't make the prophecy happen. I be in that time you did there when they do this prophecy. Anyway, my people, we not go let that one happen. No, now be the struggle where we dey here now. It no go happen. If they know how they take carry the drugs, make that thing they run for their family, make their children and their children will be say they do those things, make it for they reach them, no be to carry waiting they do, come put for the head of over 200 million Nigerians. And we as our own Esther take talk for here, talk say. It no day on the this thing of Samani to begin dey make law.
Yes.
Just like that BB Nigeria Cynthia talk say na Samani go make law. And you know that kind of thing. So no be their own. So all this one na the talk wey we go enter, but most importantly we go deal with that very particular issues where we carry enter. This one na article notice of appeal. That one we give hints for yesterday. But make we even enter P2B's notice of appeal. As he say Maxwell do tweet where we say he can highlight some places and waiting the reliefs where we say we dey seek for Supreme Court. Say and the way we take put am for in tweet in talk say the lawyers do very good job. It be like say dey for screen. He say reading this notice of appeal already reveals the strength of our brief of arguments. Remember that Justice Samani had reprimanded the lawyers for not going state by state all through the 37 states to request documents. In ground 8, P2B will argue very strongly that presidential election is a federal election and not a state election, and Section 69 and 152 of the Electoral Act considers the chairman of INEC the custodian of all documents, including statements of result and ballot papers relating to the election. So why did the Presidential Election Petition Tribunal expect P2B to be running to and wasting transport to all 37 states of the Federation to obtain documents? Now, joining us on Zoom, Maxwell highlighted many of these places and he go explain, give us. And again, the release where we say we dey seek for that very place. Maxwell, I beg, we don't dey wait tire. Make you explain, give us.
Okay, good afternoon. Good afternoon to everybody, Mr. Kanu, Angel, everybody waiting for studio, behind the camera and for front of the camera also. The well-meaning Nigerians also obedient when they listen to me. If you look, you go see say today I carry very, very plenty smiling face and joy. They come on today's program. The reason is not far-fetched. I've been going through the document, and believe you me when I tell you that the document is rich. You know, say now how this document takes strong reach. The arguments we did for the documents take strong reach. Now we go take note how the outcome of our appeal will be. So now you could see that this document is a weighty document that has about 51 grounds. Now, one thing about this entire appeal thing is there is you need to formulate grounds, that is the reasons, the foundation why you are appealing the judgment of the court of or the court of first instance. And most times you would need to state those grounds before you now go into the stage of formulating the issues to argue the grounds which you have formulated. And they formulated 51 grounds. 51 grounds. In article's notice of appeal, he formulated about 35 grounds for which they will be bringing the appeal to the Supreme Court. Now, I think it was yesterday we discussed that they filed this document, and I've been taking time to go through the document, and I've found a lot of striking things in that document. I'll analyze some of them here. I'm still doing some short, brief analysis of the documents on my Twitter handle, and of course I'll make them available on my website, which people can also further go there to read and have a full grasp of that document. I don't say to read the entire thing, they stress people. Now this particular tweet where you bring up, where they talk about section 69 of the Electoral Act, which give the provision say the Chief Electoral Commissioner now be the officer in charge, and say every document will relate to election suppose they in your own custody. Now, if you now remember when Justice Samani been they read that judgment, or if you go through the judgment documents, you would see that Justice Samani had, reprimanded. They don't already caution the lawyer, say they no agree do their work. They can't they blame people. Say they supposed to go for the states where they want the results and documents and everything, for where they go collect all these documents. But Mr. Kanu, waiting be the possibility. Say Peter Obi go they travel from state to state. Remember, say the provision of the law don't say if you want question election for anywhere, you go bring them. So he go travel from states, go collect all the results, or maybe states go still tell and say make him go local government by local government to go collect these things. And then if he can't go collect for state A, he go collect for state B, state C, like that. For 37 states, as the tribunal don't tell us, in 37 states we get for the Federal Republic of Nigeria. But of course, we know it's 36 states and the Federal Capital Territory. Now, when you look at the argument of the petitioners in that ground 8, what they tell the court be say the court failed to take cognizance of the fact that this election is a federal election, that this is not a state election where you need to collect the documents from the state electoral commissioner, in the sense that in such a federal election that has to do with the entire territory of Nigeria, that is the 36 states and the Federal Capital Territory, the major person, the CNC, the commissioner of this particular exercise, is the chairman. And of course, you see and there say for section 152 of the Electoral Act, we define who be what do they call the name, who be the chief commissioner. It define him as the chairman of the commission. So when you look at section 69 and the collective reading of that provision and section 152 of the Electoral Act, you go see say indeed the argument is very logical and very genuine that for you to be able to get these documents handy, because all of them are supposed to be domiciled with the chairman, with the chief commissioner, which is Yakubu Mahmood. So they were not wrong in their argument to have gone through the INEC chairman in requesting these documents to see that they get it in time. Imagine say you get 21 days to file your petition before the Election Petition Tribunal, and inside these 21 days you need to write arguments, you need to formulate arguments, you need to read cases, you need to refer to a lot of things, you need to file witness statements on oath, you need to reach out to your witness, you need to prep your witnesses for the case, and you still want the petitioners to be going about the whole 36 and 37 states. It does not show any sense of justice at all. It is not, one of the things we they fail to understand, we say, like Justice Chukwudifo Puta said, that what we have courts of laws, what we have existent are courts of laws. But God forbid the days that they will cease to be courts of justice. So the fact that a court is a court of law does not stop it from, effecting justice in the society. So whatever is the judgment of the tribunal should be geared towards justice and not just the technicalities of the law. And now we don't see. So there are other things about this document. For instance, you will remember, say, the Court of Appeal that is sitting as the tribunal had expunged the evidences of 10 witnesses in the case. So out of 13 witnesses, you threw away 10 witnesses. And remember, say, for this show, Mr. Kanu, I've been telling you, say, he gets one recent judgment where they've been delivered on the 10th day of August 2023 between APM and INEC and other people for the case. Where we say the Court of Appeal that was sitting in the jurisdiction of an appellate court in that case don't decide, say, where courts don't issue order, that is subpoena, say bring person come court. Is they wrong for court to consent the person go back, say you no go accept the argument or the statements of that person? In fact, the courts come talk, say, at the point, and the petitioners also they argue for this, their notice of appeal, say, as far as say they no argue against the subpoena. Remember, say they ask any objection. Nobody objects to the subpoena. They only objected to the witness statement on oath. So the subpoenas were not objected to. The subpoenas were not argued against. It shows that that document is binding, and not just binding on the court, but binding on all the parties to the case. So, even the proper say, after the court don't admit this evidence, say they binding, and in line with the Court of Appeal judgment in the APM versus INEC case. And to clarify, this APM versus INEC case, no be this one for tribunal, now another different case. And the court don't talk, say you are supposed to accept it. And for that particular case, it was a unanimous judgment by the court to accept a witness statement, even though it was not front-loaded. So by this, you see that there is a lot of strength in the argument of, Peter Obi. Another thing again that you may like to see from that document is the fact that when arguing non-compliance, the court refused to pay cognizance or take note of the fact that the petition and the respondent, that is particularly INEC, refused to call any witness to controvert the proof of the petitioners. You go remember, say, they say many things, say they no upload, they no fill form, they no write all the necessary things which they supposed write for form in accordance with provisions of section 74 subsection 2 of the Electoral Act. And because of say they no follow this thing, say it's supposed to invalidate the election results where they announce. And the petitioners brought witnesses to prove this. The petitioners brought documents to prove this. Remember, say petitioner been called a presiding officer. I think that was the last witness that they called. That is PW13. They also called either PW11 or PW12, one of the two, where one of them was a supervisory presiding officer who was supervising several polling units, who attested to the fact that some of these things were not done in the polling units. And INEC did not controvert these testimonies. INEC did not bring a witness that said otherwise. They only carry only one witness come, when no be presiding officer, where they say na ICT person for INEC. So the petitioners will also be arguing by this notice of appeal that they argued substantially the issues of non-compliance and that the respondents failed to controvert these arguments. So apart from this too, it gets other arguments in relation to the Federal Capital Territory, and like I said, all appeals are based on the law. When you want to appeal a judgment like this, your appeal is filed on points of law, your notice of appeal. So you question the law which the judge or the justices relied upon to give their judgment, be it previous cases as decided by the courts or provisions of the extant laws as passed by whatever is the legislative house, or be it a regulation and guidelines as passed by anybody in Nigeria. So that's why you see, say, when you look at that document, you see several places where they talk about error in law, misdirection, and all of that. So the court failed to consider several provisions of the law that provided for certain rules for which they are to follow before coming to the conclusion of their judgment. So they are very, very important other grounds of appeal. When you look at ground 23, you look at ground 30 and some other grounds that subsequently that we can expound upon. And anyways, that should be it for now. Then probably later in the program I'll give you the timelines on how this entire Supreme Court case will go, and the next document where we would expect and when we expect judgment from the Supreme Court.
Okay, yes, thank you very much. This thing you nail up where you even the net where you give me, I just did nod my head for here. And even people who join me for studio here, everybody just did nod their head, say yes, it say what you they talk, it they sink in. And then coming back to studio, you get something where we say Maxwell talk. He talk say then they expect maybe to be the go state by state and all that one. Yeah. The question one I want to ask for now, I start with Angel. If then they talk say make person go state by state, go bring witnesses come. Now how many people you think say fit enter that very same courtroom where then talk say make people not even plenty to come to that very place?
Apart from that one, Seth, they suppose ask INEC why they no release waiting they supposed to release. That is the first thing they suppose. Not be to tell them make they go state by state, go even if they collect and come. INEC go look and say no be our paper. They go say no be their paper be this. So waiting go come happen when they deny the paper.
The one where then certify myself, say them talk saying na blood about 800 and something thousand pages. We say they say na blood, then certify them. Still, these people talk say they no bring evidence come.
Yes, which polling unit, they're supposed to ask INEC as if you come out 8,000 something from the result where you call, where you can't get the result where you declare the person where you declare. They just decide INEC as if to say INEC na their person. Why we say INEC na independent body for themselves? Okay, before we come out, Maxwell, you say for this year too, you say P2B by his notice of appeal 6-3 release from the Supreme Court. You say one, that the Supreme Court should allow the appeal in its entirety.
that the Supreme Court should set aside the perverse judgment on the court below, that is the Presidential Election Petition Court. Then third, you said that the Supreme Court should grant the relief sought in the petition, either in the main or in the alternative. So obviously you said the lawyers offered arguments in the main and the alternative, and in the same manner, the same way they sought their reliefs. But most importantly, your number one, that the Supreme Court should allow the appeal on its entirety. And this first and second, make you for explanate, give us. This your first and second.
Okay, the thing we did there be say, when you go on appeal like this, in such cases, not only election tribunal cases, several other cases, when you approach the court, you would need to make some prayers to the court. And these prayers are what forms the reliefs that you are asking the court to grant. Because, you know, if you just go table your problem for the court go ask you, okay, you don't table the problem, what you want make I do? So most times it is always practical for you to, you know, arguments, or make prayers to the court. So irrespective of the arguments you have offered, where does your argument lead? And when you look at the prayers, number one is to, you know, uphold the appeal in its entirety. You know, say for this appeal, the petitioners go argue entirely. They go argue, say, the entire document, the entire judgment. You know, say, for some part of the judgment, they agree with some part of the judgment. For instance, where the court holds, say, Peter Obi in a member of the Labour Party, they agree with the judgment for that particular place. However, when you appeal like this, you will definitely pray the court to uphold all of your arguments. So when you see reliefs are the prayers or your request, which you are asking the court to do. So one of the prayers, we say everything where they go argue, the Supreme Court say make them uphold them. And like I tell you, this one will be the only documents where we go see. This one are just notice. This one just be like, say, not just preliminaries before the major case go come out. You understand? The major documents go come out, which I say I go still give out the timeline for this particular today event. So then another prayer is the fact that they offered that they are going to offer arguments, you know, in the main and in the alternative. From what I saw, this is my deduction from, you know, their reliefs. So you see, say most times when you argue, it is always advisable to argue and then offer arguments in the main and in the alternative, or offer prayers in the main or in the alternative, so that in the main is that this is actually what I want. But in the alternative, if you cannot give me all of what I want, or this particular thing that I want, I will be fine if you give me this other one. So those are the that's what they mean by, you know, arguments in the main or in the alternative. So, but when we see this particular argument, now when we go know, the notice of appeal is not the argument for, you know, the final argument for the Supreme Court. So that one are documents we go still come later during the Supreme Court, you know, proceedings for this petition.
Okay, we go soon talk about even waiting the Supreme Court go set out their timing for the justices will be say that is their panel where they go put together, make we know the people. But before we go more for the Supreme Court matter, he get another breaking news where we say e dey, and that very one it be like say everybody don't begin the dance for inside, and that one na Atiku Abubakar versus Chicago State University. US court no be say dem just order for the release of Bola Tinubu's record to Atiku Abubakar within 2 days. Dem talk say dem must certify am, authenticate am under oath. Na so dem take talk. This very judge no be only vex dey catch am from wetin dey hear, but if una read the document, that is the order, be na the judgment, if you call am ruling wey im give, you go know say the man see say something dey happen somewhere. Why is Bola Tinubu getting so desperate to hide his this thing? So this is his memorandum of opinion and order. I don't know whether you don't read them, you see Maxwell. If you don't read them, you go see waiting at the talk for inside. Plenty things where the man take talk. And even before we go inside there, I draw your attention to the this thing where this man talk. The same judge, waiting he use him mouth ask the question when he asks. You get them for audio. I've been a video, then they call them where in the fire questions straight to Atiku and the CSU lawyers, and the vexation where they even inside, where even anyway, make we just put on small, make we hear them before we enter to the main ruling when in give. After when in hear all the things where they talk and when in talking own, make we see how the judge take talk and first before we enter to the judgment. I be the ruling when in give, when talk say they must give account.
The Westberg affidavit says that all diplomas are signed by the current president or board chair, right?
Yes.
And that diploma purports to have been issued in 1979, right?
Right.
And Ms. Daniel was not president of the university in 1979, right?
Right. Yeah, the diploma doesn't have a date that it was produced on it, but the information on it references the graduation on that date.
Right.
The possibility, Your Honor, if we all want to go down speculation land, is that there could have been a request for a copy of a diploma 10 years later. And that was the diploma that was produced at that time. I don't know that that happened. My client doesn't know that that happened. There are some, but those are things that Chicago State can't shed any light on. But in terms of the straightforward issue, is the diploma authentic or is it a forgery? My client can't answer yes to either of those questions. And I would suggest that really should end the inquiry.
And it seemed to me, at least from public sources, that I was able to see that Elnora Daniel was president of Chicago State between roughly 1998 and 2008. Does that track with your information?
Sounds in the ballpark. I don't have the dates, but I understand that she wasn't there in 1997, which is what would be relevant to the diplomas we're talking about.
And, I think CSU having definitively said that President Tinubu went there, now has to provide the basis for that assertion and explain the contradictions in the information if they're able to.
Yeah, I mean, they have a transcript, from the university that apparently shows he graduated from there. Okay.
But where did that come from, and how was it found, and how did they know it's the same person?
Took the words out of my mouth. We've been going for about 2 hours here. I'd like to take a break. Mr. Carmichael, do you have anything to add before we do so? I want to try. So
now don't hear from Judge Jeffrey. The question where they say how they take even no say na the same person he take be, how they take no say na the same name, how they take no say na for their graduates. All these things come up for inside the court even before I give this very judgment. So if when I read the background of this very judgment, I've been a ruling on a column and I go see saying at 31 pages. But we're going to bring out the page one by one. But before we go there, make we get to Maxwell. Maxwell, this one will be say the judge, no be say only in order for the academic record. No be only academic record. You can't talk say they must swear on oath. I been at the position and they make you for explanate, give us how those things they even work. Because it be like say everybody where they for inside that school now must attend the interview where they go they swear with the Bible or Quran.
Okay, you they hear me?
Yes, I can hear you. We can.
Sorry, I didn't get your question.
Okay, the question for this judgment, I be ruling where Judge Gilbert bring come. In talk say no be only to bring the academic record of Bola Tinubu, say they must do to swear on oath to authenticate that particular all the documents where they come out from there. So I say then call and deposition for there. And it be like somebody tell me say the position for US means saying like interview, say them go begin they ask everybody where they for that school. But what about people where we say they don't die for that place where we say and then sign that document and all that? As in one interview, I be depose everybody where we say a concern to get the truth out. And then the second question when I want to ask you, now when we say article don't file an appeal, enter Supreme Court. How if we get this judgment carry and enter Supreme Court now, and we can't get all the facts we must come out from Chicago State University, how that thing fit benefit us will be Nigerians and well-meaning obedience everywhere. What would they expect?
Okay, the position here, no, they talk about everybody will be student for the school, and you know they talk about people who still their life or people who don't die. So a disposition just means a statement on oath. When you depose to a statement on oath, so now in just a B. So it gets several things where article being they ask of, and if you read the order properly, you will see say the order contains several things. For instance, and the fact say they won't use them in a foreign case, will be the one where they happen for the Supreme Court currently. The court rules say CSU shall produce all the relevant and non-privileged documents in response to requests for production. So all the relevant documents where they don't already ask for, now they go produce like this in request by article. Another thing we be saying that the subpoena where the applicants don't also make, say they go provide them within 2 days of the entry of this memorandum. Immediately they don't certify this judgment, as they don't enter them as the memorandum, opinion and order of the court. They will begin the count 2 days, that is 48 hours from then on, for the production the production of this document and everything where they go need. Another thing also we did there be say the rule 30 sub B6, the position of respondents corporate designee shall proceed. Remember, say there be a request for a particular deposition will be the statement on oath what I've been tell you by a particular person from a particular office. So what in the court just mean by that be say this one too, say they go provide them, and this provision where they go do them within the same 2 days will be 48 hours where the court don't request. Another thing where the court also talk be say between article and CSU will be Chicago State University, they fit decide on the Can you hear me?
Yeah, I can hear you now. Go ahead.
Hello? Okay.
Yes, I
so
can hear you.
Another thing where the court rule be say the parties fit decide to modify the dates where the court don't set by mutual agreement. Meaning say if the court order be say make them provide all these things within 48 hours will be 2 days. But say between Chicago State University and article, say they fit come together, decide and agree on when they want produce them, but the court don't already give 2 days. So if article say, okay, he may want give them 7 days to produce, no wahala. The court don't already give them the opportunity to do that. So, and the court also take cognizance and say, time frame day for this matter. You understand? So say this whole thing fit happen on even day when no be a weekday. Say even if they agree, for instance, say article and CSU later agree, say they go use 7 days. Say no problem, say they fit do them on weekday or the day will not be weekday because of say the matter dey urgent and it get time frame. Say article don't already file a notice of appeal, and now Ingo need to work on an arguments for this case. So as it be like this, by the court order, now 2 days then get 48 hours to produce these documents, these depositions, and many other things that article has requested for. So the court don't give the order, and of course it is signed by the magistrate judge for the case for United States, Jeffrey Gilbert, on September 19th, 2023. So it stands. That's the current position.
Okay, we get somebody will be say there for our comment section. In talk say whether Tinubu will appeal this very judgment where we say they come out from that very side. But I don't think so, because Tinubu no be party for that matter. It's just an interloper, if you ask me. But make you for answer. Now you sabi this thing as it be like say their side, how did they work there? They're different from our own here.
Well, the thing they say, I don't know how these their rulings work, but most times their court systems not be like our court system. So they get something more like a regional court system or a state court system, whereby no be like here where we say every matter go wrong come Abuja for Supreme Court, where they for Abuja. So there are procedures to these things, and you would recall that the only provision there, the case only border on what thing they call them, Bola Tinubu to come there as the case is an application by Atiku Abubakar for an order directing the discovery, into documents that are being held by Chicago State University. The only thing is that they brought in Tinubu to come and show reasons why Chicago State University should not release it. So I really cannot state for now, because I am not so conversant with the United States, court system and the possibilities of appeal. Even if there is a provision for appeal, I know that these things will be done within good time. But good time here we are talking about is just something about 7 to 10 days. That I can guarantee you, because this is when these timelines begin to run for the petitioners to file their cases at the Supreme Court, both for Atiku and other people in this particular matter in Nigeria.
Okay, thank you for that explanation where we say you give us. I know say Bola Tinubu no be party, even for the front of the judgment, be the memoranda of the ruling where that very district court Judge Gilbert give. I know see Atiku name for there, and a person will be party for matter na him fit appeal. I think they invited him to come and talk in that very place. You can see him for here now as he did for screen in this memorandum of opinion and order. It's an application of Atiku Abubakar for an order directing discovery from Chicago State University pursuant to one section of their law. So Tinubu know they, I think they now Tinubu carry mouth go chook for there saying they're interested, and then Chicago State University can't allow making contact, because then talk say they know if you defend them for waiting they happen for there for all the things where they happen. So maybe you can't use the mouth talk. So now then can't join issue. So for person will be say if they ask this question, I no sure say any appeal concern there. And this one na order where they directed to the waiting they call in Chicago State University. And the 48 hours don't begin the run for person will be say they ask about whether it done the run or not. The 48 hours don't begin the run. So by tomorrow we shall have the thing will begin to enter one by one. And again, before we come out from here, make una no forget say we still dey expect 2,500 documents of Bola Tinubu's files from FBI, CIA, the one where they talk say they go they release every month. Yeah, so we dey expect them. And make una go even check, make una go Google. Go check Wikipedia, see which person FBI file they reach that kind quantity. Wetin that person do where in file go reach like that. Anyway, we'll come back with that very one and the other one. Make we come back for studio here, because we get other things where we say we won't discuss where concern this Supreme Court matter, and our own princess carry am. The thing where Princess Oluchi General Oluchi tweet, we go highlight them as princess where they here. When up another Princess Oluchi again, he go make he bring the thing out, make our own Maxwell can deal with them. But first, make we give and credit the distinguished field marshal General Oluchi. We heard you, and this thing when you bring about Samani's ruling, the thing they very, very okay. Make our own princess come use her own mouth, come bring her out for our people. Make Maxwell come now give us his own legal this thing.
Okay. Part 1, Samani's ruling on September 6, 2023. I have a problem with this particular paragraph because Samani gaslighted the issues by claiming that LP and OB did not specify the particular polling units or specific places where the alleged irregularities and malpractices happened. This is a lie because there were so many back and forth in writing before the hearing commenced and witnesses were called and evidences dropped off. A witness from Adamawa testified that he witnessed anomalies at polling units. His witness statement was submitted in court, but did Samani and his friends read it? The boxes of evidence presented in court had lots of blurred and scribbled results on them. Did Samani and his team ever check those documents to understand why they were brought to court? No, they didn't. Okay, let's flip it. Did INEC present all the documents required to clear them from all accusations? Lastly, INEC never disputed cases of irregularities and malpractices. So where did Samani get this angle from?
Yes, this one, where did Samani get this his own angle from? That one, that's why they call him the rogue judgment. Now, she come bring out the environments where they for inside that very particular thing. He say, a look at the environment in the petitioner's petition shows that the petitioner has only alleged various irregularities and malpractices, but failed to specify the particular polling units or specify places where the alleged irregularities and malpractices has occurred. This one, as Samani, they talk this one. No? For instance, in paragraph 9 of the petition, where the petitioner averred that in appropriate cases, these agents raised complaints about anomalies where they occurred and reported such complaints to designated officers of the second petitioner and the first respondent. The petitioners failed to specify the anomalies, the places where the anomalies occurred, the agents who complained, the designated officers of the second petitioner and the first respondent to whom the complaints were made. In paragraph 60 and 61 of the petition, where the petitioners allege that the first respondent suppressed the actual score obtained by the petitioners by deliberately uploading blood from EC 8As. Now, this one, now waiting come out from that very judgment. Our own Maxwell, before we go to part 2 of this, waiting you think for this very particular thing, because waiting distinguished Oluchi, they talk for that very place, you don't hear them, and you see where she bring out where that man, the lying face, go put for their judgment, but Oluchi disagreed. You now will be say you dey close to court, even during that court proceedings, you dey there, and you dey bring out these things, even from your own tweet or X platform. Tell us, as Oluchi take talk her own, wetin you see, wey be say you be eye observer for there.
Refused to take cognizance of evidences that were deposited before it. Now, when you see, we carry several boxes of evidences take enter court. In fact, we carry many buses take bring the evidences come court. But it is very unfortunate, say, the court refused to take notice of these documents, and not be only say the petitioners bring the evidence come court, but the fact say the petitioners argue the documents, you know, each one of them making reference to it, and they brought witnesses. And I'll tell you one of the reasons. One of the reasons where be say the court refused to take cognizance of this, be say some of the witnesses will speak to these documents. The court been already pursued them from court. Remember, sir, I tell you, say about 10 of the 13 witnesses where Peter Obi carry come court. The court pursued them, say he refused to collect their testimonies and their evidences. So now one of the reasons why they can't do like say they don't know, say they don't argue some of these things. And apart from that, remember the provisions of that should be section 137 of the Electoral Act that stated that where you want to prove non-compliance in such instances and you are to bring evidences to prove, it is not a must for you to even call witnesses to come and prove it.
That one dey for law. So whether they called witnesses to prove or not, if they brought substantial evidences and documents before the court to prove these things, it is enough. And you go agree with me, say, when I've been dey court, they report all these things, they even show pictorial views of all these things. I showed several boxes of evidence, trailers of evidence, boxes of evidence where they carry inside. Some of us even teaching a puff puff, they put inside the box where they want to take share for people wey come court. But now social documents, election results and election materials wey they carry come court. So it actually shake my mind, say the court go look custod this kind of thing, say they no bring evidence, they no do this one, say they expect the court to go find evidence. So I do not agree with the court's position. And like I don't also tell you, for these documents, you go see say na the same thing where they go argue. Even for ground 15 of the documents, they argue against the fact, say the court even pursue some of the witnesses, sake of say the witnesses say they get interest for the matter. But the respondents no even prove some of these things. So wetin General Olichi talk now correct summary of this particular petition, this particular judgment where we don't already they discuss, they analyze, different people they write about, and different people they give several opinions about it. And you would agree with me that all these opinions make a lot of sense. Go people will be lawyer, people will not be lawyer. So now him be that.
Yes, sir. Yes, I think you are just right. I like that's why eyewitness they good as you did there. If you look at part 2 of distinguished field marshal here, he says that
Judge Samani said, it should be noted, however, that not every ground of non-compliance will amount to corrupt practices. In fact, the standard of proof of non-compliance differs from that of corrupt practices. Non-compliance simply means that INEC failed to follow the guidelines stated in the 1999 Constitution and the Electoral Manual. Failure to follow guidelines opens doors to corrupt practices. INEC produced a president through non-compliance, and Samani couldn't see the problem in that. My question to this man is, if the process is wrong, would the outcome be right? How did INEC arrive at their conclusion through non-compliance? Isn't it a corrupt practice to pronounce a winner through blood and invisible results?
Our own Maxwell, over to you. Why would they produce their so-called president with a blood result and they didn't see anything wrong with it?
You see, the issue of non-compliance and corrupt practices are usually linked up. They are usually, in fact, when you look at the grounds for which a person can bring an election petition, usually what the provision of the law does is that it listed it in the same place. It lumps it up, because when you are looking at corrupt practices and you are looking at non-compliance gives you the leverage to actually effect, corrupt practices in the job. Because if you fail to comply with the provisions of the law, it is one thing. So by not complying, you can simply cancel the election. If you realize that presiding officers did not comply with the provisions of the law, then if after not complying with the provisions of the law, you now proceed to announce results when you know that it is against the provision of the law. Mr. Kanu, remember, say for this same Electoral Act, you get places where they don't already talk, say anybody will fail to do this thing, say he get punishment. For instance, under section 73, subsection 3, he say anybody will fail to fill all the relevant information for all the forms EC8A, EC8Bs and the rest. Say it dey necessary, say make them arrest this person, prosecute them, and put them for jail. So by this, it shows that it is a corrupt practice not to even, follow guidelines, and then you proceed to announce a winner. So it is enough corrupt practice to even show that they proceeded to announce somebody a winner in an election where they could not even, ascertain the procedures of how the person won. So that's the major problem. They are things that flow in the same occurrence of events. You fail to comply, therefore giving you the leverage to, corruptly announce somebody as the winner. And we saw it in by 4 a.m. on the 1st of March, where they proceeded to announce this man as winner of an election.
Okay. And then part 3, it says Samani's PEPC ruling on September 6 says Justice Samani stated that the petitioners failed to specify anomalies, how INEC transferred Obi's votes to Tinubu, the places it occurred, and the agents who complained. He said, my response here is, one quick look at Form EC8A will tell you all you need to know about each polling unit. But unfortunately, Samani and his team did not check those documents submitted as evidence. 1, a blood or doctor election result is an anomaly. 2, a physics exam question in place of a result uploaded in C8A, which we all saw on IRAVE, is an anomaly that does not require special eyes to see. 3, Samani gave his judgment based on incomplete evidence. INEC failed to avail documents to the LP legal team and Samani excused them. He actually encouraged them not to. 4, if you check the EC8A, you will see that the polling unit, ward, state, where it happened, and these documents were given to Samani, but they did not check it. Once again, Judge Samani proved incompetence in this case by failing to apply common sense and thoroughly reading the documents before him. So, Maxwell, wetin Oluchi conclude, we say that it be like say they no read this document, because when you go through this their petition, be like say they no read the document. If they read them, they no come out with this kind of result. But anyway, now the story we don't carry go Supreme Court now. So wetin we dey expect from Supreme Court, we go dey bring them out one by one after all the reliefs where we seek when we go inside the documents itself. Like all these blur results where we say we dey show for screen now, we don't dey show and tell all the things where we say they there. They no mention all of these EC8 forms where they're mutilated. Not, let's even leave the blur ones, but the one where we say they change the result where they're inside, they no talk am. Are they actually expecting that Peter Obi and Atiku Abubakar will bring all the polling unit officers to them? Are they expecting the subpoenaed witnesses to be present while they are rushing to file their petitions? Anyway, Maxwell, what I want get to you now, finally, this one where we don't carry enter Supreme Court, this matter where would they get from US where they come? If we get all the information where we want, Supreme Court go still entertain them.
Of course. If you know, so I don't talk. I'm here several times. Say they get several case laws to this effect. Where be say anything we don't make a matter go on appeal. Where be say you don't reach either Court of Appeal or Supreme Court. Say whether opportunity is still there to tender new evidence to the court. And I tell you, say the answer now yes. It is possible for them to tender new evidence to the court. Sake of say he get some grounds where they go fulfill before the court go accept new evidence. One of these grounds we say maybe say at the time when they been hear the matter for first instance for tribunal, say the evidence be no dey available. Another ground be say the evidence relates to the case, and of course it go dey very material in the correct determination of the case. Another ground be say it is in the interest of justice and equity and fairness. Maybe say they add this thing. So all these things follow for grounds for which courts will take accept new evidence. And yes, it is possible for the Supreme Court to accept this evidence.
Yeah, thank you very much, Maxwell. We will see you back again this evening because we won't study these two documents where we get the other one where they come out from USD at something documents, and if we combine article own and P2B own, that one don't they pursue 90 to 100 documents. So we'll go bring out those things when we come back later today again, and many other things we will carry come. But I want encourage obedience worldwide, say hope day. Now the thing where they preach every day, and wherever you do, where they watch and they listen to us now, make you for like and share, make other people get notification, make them they hear the message of hope where they come out from here. Now waiting you fit contribute for the new Nigeria where we they talk. Now the support where you fit give P2B at this point, aside from your prayers, make you for like and share, make other people understand say progress dey, because then they buy people over, then they feed them wrong informations where some people go begin the jump fence, like the one where talk say you know they sit for fence again, will be brother of Dati Baba Ahmed. But that one na in talk na in own. Anyway, Esther, yes, you want to do
anyway, General Oluchi don't talk everything finish. We don't say even little children wey dey for street, they see as Samani and in legal panel just bogle everything out, just bogle our case out just to give Bola Tinubu a very soft landing. Now the thing be say the tribunal held to nullify the presidential election that was held on 25th of February because of non-compliance to INEC electoral law. They don't even stop there. They can't petition. They don't give. They can't query the petitioners why they no go give this, which is not in their possession. Now, according to what Yusuma talks, say how they expect P2B, PO to they enter go the 37 states, including Abuja, where they don't turn to states. Now, they go there to bringing up petitions and law results and everything.
I think what you talk now, that matter now go enter Supreme Court. So Supreme Court go look am, and this one not be only our eyes on the judiciary again. This one now our ear, nose,
everything.
Mouth, everything. Now we'll carry go. With that very one, I'll carry and give Angel Meshi for pack our kaya come off for studio.
My well-meaning Nigerians, my lovely and intelligent, obedient worldwide. Una don't hear everything, una don't see am. We are so happy. You see this news from Chicago State University. The thing they sweet my belly. And I know say they sweet your belly too. Because na great news. You see how US judges, they deepen their democracy. Come to Nigeria. See how Samani and in cohorts just they destroy our own democracy. They turn constitution upside down just to favor one person. But it no go happen. You see this, no wonder they say all eyes on judiciary, they prick their conscience. If they disturb them, if they distract them. Now we see them. Now our eyes, ears, nose, all our body go there for Supreme Court now. Our searchlight, we don't put them for Supreme Court. Make we see whether they go write their name in gold or they go rub their integrity in mud. Thank you so much. Like, subscribe, share, make other obedient they hear. This one na evangelism. Thumbs up to the video. Make other obedient worldwide they hear. Waiting they happen so that evangelism go day on. My people, we love you. We thank you for being with us. Maxwell, we appreciate you. God bless you for being with us. Thank you so much for being with us today. We love you, but God loves you more. Bye for now.